Hello, Daniel Barnett here, and welcome to episode 25 of Employment Law Matters. That's a quarter of the way to episode 100. And today is Christmas week. In fact, it's Christmas Eve. What are you doing listening to podcasts? I thought this week I'd cover something really practical, which creates a lot of hassle. Recording meetings at work. Contemporaneous notes are all well and good, but can anything really beat a recording and a transcript of a meeting between employer and employee? Often employers are reluctant to record meetings, but there's generally no need to be.
Welcome to Employment Law Matters with Barrister Daniel Barnett.
There's nothing to stop an employer and employee agreeing to record an internal meeting, whether it's disciplinary, grievance, investigatory, performance management, or anything else. I actually record most client meetings, and then I use a transcription service to transcribe it, and my clients always get the transcripts of our meetings, which is incredibly useful. I use a transcription service called rev.com, R-E-V, rev.com. They're a US-based company. They charge $1 per minute of recording. So a 30-minute recording of a disciplinary meeting would cost $30 US to transcribe. I've actually got, for everybody listening to this podcast, a special link. Tell the employee why you want to record the meeting and explain what you'd like to record and who'll be allowed access to it. And get their written consent. You're processing personal data, so the usual rules about data protection apply. If a meeting's going to be recorded, it's usually best to take control of it. Use your own equipment, any iPhone will do, and ensure that the recording and any transcription is safely stored. Then there's the far less straightforward and the frankly downright sneaky approach to recording meetings, which is doing it without telling the other side you're doing so. There are various reasons, but they usually hinge on a need to capture evidence. Employers have to have a really, really good reason to record their employees without their knowledge. It's usually only in cases of suspected criminal activity, where there's a credible prima facie case existing, that deploying a recording device would be justified. By far the better approach is to be upfront. The situation's a little different if it's the employee doing the recording. Now, you might never know if the employee has covertly recorded something, because maybe the recording does them no favours, maybe they're happy with the outcome of the meeting. But if a tribunal claim ensues, there's always a chance that a recording which supports their case will be produced. And the bad news for an employer who made an unwise comment during the meeting is that tribunals almost always allow covert recordings to be relied on in evidence. They'll say, "Tut tut, that was really naughty, don't do it again, now let's listen." Now, it's different if the employee has left their recording device running so as to capture private conversations that took place while they weren't present, such as the disciplinary panel's decision-making discussion. That's usually inadmissible. But in a discrimination case, if that recording proves the only and incontrovertible evidence of discrimination having taken place, then a tribunal might allow it. It's also been held in a case called Fleming against East of England Ambulance Service NHS Trust that an employee can rely on a covert recording of the discussions between panel members during breaks in his disciplinary hearing, without which evidence it wasn't possible to properly assess the decision to dismiss. But any evidence covered by legal professional privilege wasn't admissible. Given the risk that private conversations can be recorded and in some cases used against employers, you should make sure that risk is understood by managers and by others who run internal meetings. What about disciplining somebody who covertly records a meeting? The starting point, as usual, is the disciplinary and grievance procedure. if it expressly prohibits the recording of hearings and meetings and spells out the possible sanctions if someone does so, you've got the basis to take some action. The reasonableness of that action depends on the circumstances. Consider what the employee was hoping to gain from the recording, and whether disciplining him or her could give rise to another potential claim against you. I'm thinking of a victimization claim. But is covert recording a breach of the implied term of trust and confidence? That's a question recently considered by the Employment Appeal Tribunal in a case called Phoenix House Limited against Stockman. The employee had been dismissed following the breakdown of the employment relationship. She later produced a covert recording of her meeting with HR and went on to win various tribunal claims, including unfair dismissal. One of the points argued by her employer was that making a covert recording breached the implied term of trust and confidence because it was dishonest conduct designed to obtain an advantage for the employee. But the Employment Appeal Tribunal held the tribunal was right to assess all the circumstances. Ms. Stockman had not recorded covertly to catch her employer out. She'd recorded covertly because she was concerned with her own position and wanted to protect her own position. The Employment Appeal Tribunal set out some helpful observations and guidance on covert recordings. Here's what it said. Number 1. It's not now uncommon to find that an employee has recorded a meeting without saying so. 2. A recording is not necessarily done to gain a dishonest advantage. It might have been done to keep a record, to protect the employee from any risk of being misrepresented, including in notes taken by HR, or to enable the employee to obtain advice from a union or elsewhere. 3. A tribunal is not bound to conclude that the covert recording of a meeting necessarily undermines trust and confidence. 4. The purpose of the recording will be relevant. Is the employee highly manipulative? Maybe they're confused. Are they vulnerable and seeking to keep a record or guard against misrepresentation? 5. The extent of their blameworthiness may be relevant. Have they been told a recording must not be made? Have they lied about making the recording? 6. The subject matter of the recording is also relevant. Is it a meeting that would normally be recorded in some form anyway? Is it about highly confidential business matters? Was personal information about another employee discussed? 7. Is covert recording listed in the disciplinary procedures as gross misconduct? That's unusual, even nowadays. 8. It's good practice for an employee or an employer, if they intend to record a meeting, to say so. In ordinary situations, failing to say so will generally amount to misconduct. 9. If a meeting is long, a summary or note will sometimes, and I emphasise the word sometimes be of far more value than a recording that may have to be transcribed. Now, a few points to highlight from that. First of all, a covert recording by an employee will, in ordinary situations, amount to misconduct, but not necessarily gross misconduct. Make sure your disciplinary policy lists it as an example of gross misconduct and make sure that's communicated to staff. Second, the fact an employee has covertly recorded a meeting won't necessarily undermine mutual trust and confidence. Finally, even if the employee has acted improperly, that recording will normally still be admissible in a tribunal. It's a tricky subject, and the safest position for any employer is to overtly record things itself, therefore it is in control of the meeting and the record of the meeting, and to have nothing to fear from their words being replayed. And key to this, in my view, is to have excellent policies and processes and managers who understand exactly what to do and what to say and what to avoid during meetings with employees.
Any information on this podcast is for general guidance only. Always seek legal advice. Please see full terms at www.danielbarnett.co.uk/podcast terms.